Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 168. I'm Nicholas Robertson, head of the Mayer Brown employment team. This is the Mayer Brown Employment Law podcast, our regular update on matters of importance for employers in the UK and occasionally further afield. This podcast is the companion piece to the one that we recorded on the furlough scheme. This is about the Emergency Volunteering Leave Scheme. The Emergency Volunteering Leave Scheme is contained in the Coronavirus Act 2020, and although it's not in force as at this precise moment, it's about to be implemented. And I wanted to focus, there's a whole battery of things in there of significance, but I wanted to focus on the Emergency Volunteering Leave Scheme because I think it's important that employers know about their obligations in relation to this, but also some of the questions that it's going to raise have also been thought through before they become real issues. So the Emergency Volunteering Leave Scheme, the scheme, is set out in Schedule 7 of the Coronavirus Act. And it says that a worker is entitled to give, or needs to give, no more than 3 working days' notice to an employer in writing that they're going to be absent for the purposes of the volunteering scheme. The notice is to specify the period of the absence and is going to need to be accompanied by an emergency volunteering certificate. This document will be issued by one of a specified list of authorities, such as a National Health Service Commissioning Board, a County Council, a London Borough Council. Certificate will confirm to the employer that the individual has been approved as an emergency volunteer and will be acting as such in the period set out in the certificate itself. The volunteering period is to be either 2, 3 or 4 consecutive weeks. And a volunteer can only do one such stint in any 16-week period. The scheme provides that there will be 16-week cycles, and so the first of those will run from a start date that's yet to be identified, and then the emergency volunteering leave period will run from that. So I suppose if an employer volunteers at the end of one week and one period and at the start of the next period, it's possible they could be off for 8 consecutive weeks, the last 4 of one period and into the next 4 of the next period. Obviously, we'd assume that's pretty unlikely. The right applies to all workers. That's the next point to bear in mind. There's no qualifying period of service or anything like that, and it applies as well to almost all employers. The most relevant exception for our purposes is going to be employers who have fewer than 10 staff on their payroll. They are outside the scope of the scheme. So, what are the employer's duties towards workers who wish to volunteer? Well, during the period of absence, the volunteer remains entitled to benefit of all the terms of employment which would have applied to them had they not been absent. And similarly, they will be bound by the terms of their contract, which are not inconsistent with them doing volunteering leave. That continuation of rights obviously excludes remuneration. Legislation clarifies that only sums payable to an employee by way of wages or salary are going to be classed as remuneration. This framework, of course, is familiar to employers from the maternity leave provisions, for example, and so presumably case law interpreting what amounts to remuneration will apply equally to those on volunteering leave. Non-cash benefits will continue. Some circumstances, bonuses may be payable. Childcare vouchers may be viewed as remuneration, but that's not entirely clear. And there are specific provisions relating to pensions and which imply an emergency volunteering rule into employment-related pension schemes. But beyond that, it's probably not safe for me to talk about pensions. We have a specialist pensions department for that. A volunteer has the right to return to the job in which they are employed before their absence, and their seniority pension and similar rights must be unaffected by the period of absence. Likewise, terms and conditions must be no less favourable as a result of the absence. And again, employers will be familiar with these rights from the rights applicable to those taking maternity leave and those in particular returning after a period of ordinary maternity leave. One would hope that for a short period of absence, such as the volunteering leave, there will be relatively little difficulty in slotting an individual back into their job. But, however, if there is a dispute, presumably the courts will look to the maternity provisions as interpretation. Case in that regard, Blundell indicates that the issue, if you're taking someone back into their job, it's not simply a matter of looking at the terms of the contract. The job should be as near as possible the same one that the individual was doing before they went off. And of course, in circumstances where individuals may be volunteering at a time when the employer itself is restructuring and reorganising, you can see that there may well be some issues. Equally, you'd certainly hope that employers and employees will be tolerant and understanding. There are, of course, protections for volunteers and those looking to be volunteers, and employers need to be aware of those protections. A worker must not be subjected to any detriment by any act or deliberate failure to act by the employer on the ground either the individual was a volunteer or that the individual was looking to become a volunteer, or that the employer believed that the individual was likely to volunteer. There's similar protection against the dismissal of a worker as a specific form of detriment. For an employee, there's no, if you're going to bring a claim for this protection, there's no period of continuous employment needed. It's a day one right. It's automatic unfair dismissal. There's no cap on the unfair dismissal damages. And similarly, if an employee is made redundant for reasons connected with their involvement or likely involvement in the scheme, then that too will be an automatic unfair dismissal. So, what sort of problems do we think this scheme might create? Well, I think the first point is that 3 working days is precious little time to prepare for an absence from work of a key member of staff, especially if there's no mechanism for the employer to delay the period of leave. And there is no mechanism for the employer to delay the period of leave. It just is what it is. So we suggest the employers make clear that periods for volunteering under the scheme will be supported, but that workers should ideally let employers know if they are thinking of applying to be workers, so that appropriate arrangements can be made to cover work without undue disruption to colleagues. Obviously, that then is a bit like a woman telling her employer that she's pregnant. At that point, the employer can't deny knowing that she's pregnant. So if the employer were to then do something adverse towards that employee, it will have to get round the fact that it will need to show that it wasn't doing that because it knew the individual was going to volunteer. But again, out there in the real world, we think it's better that employers are forewarned if the employee chooses to tell them. But bear in mind, there's no obligation on the employee to give them more than 3 working days' notice. The employer, of course, might go the other way and encourage employees, or some of them, to be volunteers. The widely reported example in Australia of Qantas encouraging staff to work at Woolworths, I think, is one of the ones that you frequently see cited. And it'll be interesting to see whether employers take up this opportunity. The right applies to anyone who is a worker, and that's defined in the Employment Rights Act 1996, Section 230. That's the standard definition, and broadly, and catches anyone who's an employee and anyone who's working for someone else who's not genuinely self-employed running their own business. There are special provisions attending the scheme to agency workers, given, of course, that we know how difficult it is to be clear as to whether or not someone is a worker. Obviously, that's a scheme that that's a qualification that might produce some litigation. Again, you would hope in these circumstances it won't, but who knows? What happens if the employee is already under notice when they come to the employer and say they're going to be volunteer? In those circumstances, the employer's obligation to continue paying notice pay is not interrupted when they go off on the scheme. Schedule 7 provides the employer will continue to be liable for notice payments to the member of staff during the volunteering period. how that would interact with any payments being made by the volunteering scheme directly to the individual for their time, we don't yet know. It's obviously going to be a difficult situation where the employer is going through a collective consultation process and employees are applying to be volunteers at the same time. Employers may be concerned about the risks of making those staff redundant, and of course then those staff potentially claiming they're being made redundant because they've gone for the volunteering scheme. I think then the onus is going to be heavily on the employer to make sure that its rationale, its criteria are evidently objective, dispassionate and unconnected with the scheme. But an employer is going to want to be very careful. And if an employer under financial pressure is trying to rush through redundancies, that's one thing, that's one corner it does not want to cut. It does want to be very clear about why it is choosing, who it is choosing. What happens if the employee becomes sick during a period of volunteering? Well, the employer is not obliged to provide remuneration, according to the scheme. And in the context of maternity leave, it's been decided that sick pay is remuneration and so would not be payable. Obviously, an employer may take the view that it's the right thing to do to provide financial support, especially if the pay for being a volunteer, directly from the volunteering authority, is conditional on the individual actually doing the voluntary work. We do think that the employee is still obliged to tell the employer that they are sick, even if they're on a period of voluntary leave, because the obligations set out in their contract with the employer continue to apply. Most employers have a clause in their contracts requiring employees to report in if they're sick, and we think that'll continue to operate. Employers will want to know if their staff are sick, as it will help with planning the return to work, and equally other employees may then be at risk if someone goes down sick not long after ceasing to work actively at the employer. It's not clear what happens if the employee bails out on the volunteering scheme partway through a period. There could be a whole range of issues, from a family member getting sick, for example, to concerns about risk of contracting the virus from the particular volunteering work they're being given. Or maybe the employee just has second thoughts about leaving colleagues to carry on increased workload. We've no details yet as to how this would work out, and whether the employer could say to a volunteer, well, you're bound by your notice to me, and I cannot then be criticised for not taking you back during the period of volunteering leave. I assume this is unlikely, but again, it's one of those things I think employers should think about in advance, because the answer is not entirely clear-cut. So, remains to be seen how widely used the volunteering leave is, but if the reported flood of volunteers for the what's been reported online about the NHS, helping the NHS in its time of need, is anything to go by, then you'd certainly anticipate that there will be plenty of people looking to make use of the volunteering scheme to try and help the country through in these very challenging times. So there we have it. That's the Emergency Volunteering Leave Scheme. I hope that was useful. Can't promise there won't be anything else on coronavirus in a subsequent podcast, but let's see. I think my aim would be to do a normal one, if only just to maintain that sense of normality for us. And until the next time, take care of yourselves, stay safe everyone, and thank you very much for listening to the podcast. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.